Hello guys, this is Sanjana Parihar, an intern at LEXIS and Company, and I'm pursuing BA LLB. This is my first year. Today we'll discuss about this Supreme Court rules on future retail versus Amazon, where recently the Supreme Court upheld the enforcement of an order by Singapore International Arbitration Center, emergency arbitrator that puts on hold the future group's deal with Reliance Industry Limited. Now, what is Singapore International Arbitration Center? It is a non-profit international arbitration organization based on in Singapore, which administers the arbitration under its own rules of arbitration and the United Nations Commission on International Trade Law arbitration rules. Let's see the background of the case first. In August 2020, the Future Retail Limited had announced that it would sell its retail and wholesale business to Reliance Retails. Now, before the deal could be executed, Amazon objected to it, alleging a breach of contract it had with the Future Coupons, the promoter firm of Future Retail. Amazon said that its agreement with Future Coupons had given it a call option, which enabled it to exercise the option of acquiring all the parts of Future Retail's share upholding in the company within 3 to 10 years of the agreement. Subsequently, Amazon took Future Retail into emergency arbitration before the SIAC where an emergency arbitrator barred the latter from proceeding with the deal. Now, what's emergency arbitration? It's a mechanism which allows a disputation party to apply for urgent interim relief before an arbitration tribunal has been formally constituted. Now, what's the significance of Supreme Court's order? Dismissed FRL's argument that the emergency arbitrator is not an arbitral tribunal under the Arbitration and Conciliation Act of 1996. It upheld the validity of the EA award. The judgment laid down that the award is exactly like an order of an arbitral tribunal contemplated under Section 17 of the 1996 Act. Hence, an award by the EA was like an order under Section 17(1). Interim measures ordered by an arbitral tribunal of the Act. Now, Section 17 of the Act prescribes the mechanism for parties of an arbitration to seek interim reliefs for the arbitral tribunal during the pendency of the arbitral proceedings. EA orders were an important step in the aid of discongesting the civil courts and affording expeditious interim relief to the parties. The court pointed out a recommendation that high-level committee constituted by the Government of India under the chairmanship of Justice B.N. Sri Krishna to review the inconstitutionalization of the arbitration mechanism in India and look into the provision of Arbitration Act after the 2015 Amendment Act gave in its 2017 report. It said that given the international practice is in favor of enforcing emergency awards, Singapore, Hong Kong and United Kingdom all permits enforcement of emergency awards. It is time that India permitted the enforcement of emergency award in all the arbitral proceedings. Now, the judgment would serve as a reminder to the parties to carefully agree to the terms and conditions of the arbitration. No appeal would lie under Section 37 of the Arbitration Act against an order of enforcement of an emergency arbitrator's order made under Section 17(2) of the Act. No appeal would lie under the Section 37 of the Arbitration Act against an order of enforcement of an emergency arbitrator's order made under Section 17(2) of the Act. However, Section 37, unlike Section 34 of the Act, is silent on the limitation period of filing an appeal. What are the benefits of this? It would bring about parity among all the stakeholders in the arbitration process, checking misuse of the provisions under Arbitration and Conciliation Act of 1996, would save the taxpayer money by holding those accountable who sip hold of them unlawfully. There are also some drawbacks that I think they're there. India already lags behind when it comes to enforcement of international contract and agreement. The act can further hamper the spirit of Make India campaign and deteriorate the rankings of in ease of doing business index. India aims to become a hub of domestic and international arbitration. Through the implementation of these legislative changes, resolution of commercial disputes could take longer duration now onwards. So this was it for today. If you have any questions related to the content, do let me know in the comment section. I'll get back to you as soon as possible. Do let me know the feedbacks of the content too. And also, this video does not solicit any kind of promotions or advertisements according to the Bar Council of India, and this is for educational purposes only. Thank you. Do let me know how did you like the video, and subscribe LEXCLIQ for more videos like this.